Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Jonathon Kappy.
And I'm Mohena Singh.
Welcome to Hull on Estates. You're listening to episode number 653. And today we're going to be talking about the Court of Appeal decision in Fair and BMO Nesbitt Burns. So how are you, Mohena?
Doing well.
We got a little snow this week, so it finally feels like winter.
I know. Too cold for me, but...
Yeah, well, it's good if you're a skier.
That's true.
So we wanted to talk about this new Court of Appeal decision. Some of it retreads upon Moore and Sweet and goes a little further in discussing, well, we let Moore and Sweet go, but this one we're not, and the court gives some explanations why. But there's also a bit of a new thing that I'm not sure, I'd ever really turned my mind to. So why don't we get into the facts, and then we'll start talking about the analysis that the court employed. So why don't you start us off?
Sure. So in this case, Mr. Fair and Mrs. Fair invested together with BMO Nesbitt Burns. So they had a few investment accounts with them, but they were not joint accounts. Each were the designated beneficiary on each other's investment accounts. BMO would regularly deposit funds from their investment accounts into their joint account, and then the couple would use those funds in assist in paying their expenses. BMO would also share the account statements with both spouses. But however, shortly before Mr. Fair's death, he changed the beneficiary designations on his investment accounts he held with BMO. So he changed it from his spouse to his children from a former marriage. And Mrs. Fair found out about the change after his death. So she brought a claim against BMO as well as the children and his estate. So the first claim she brought against BMO was that she alleged the change was a breach of an agreement she had with the deceased and brought an action against BMO, alleging that they had violated a duty to advise her of the change when it occurred. She also sued the children and the estate, alleging a constructive trust over the proceeds of the investment accounts based on the doctrine of unjust enrichment. So on summary judgment motion, the action was dismissed, and the Court of Appeal agreed with the motion judge.
So so I think it's really important to start by talking about the fact that this was on a trial, right? This was a motion for summary judgment. So not only did the court find that the claim had no merit, it decided that there wasn't even a triable issue that was, that was required. So the analysis breaks down into two different parts because we have two different groups of defendants. As you said in your description, we've got the first sort of defendant is BMO. And so they got sued on the basis that, when her husband changed the beneficiary designation, that the bank had an obligation to tell her. And she did this on the basis that, well, it's not a bank that's the person, it is a financial advisor. And that's different than just being a bank. And that we both retained his financial advisor, and that he reported to both of us together that we had always known what each other had. And the financial advisor has an obligation to let me know everything that I need to know in order to properly manage and invest my assets. And that was the root of the allegation. The Court of Appeal was correct in identifying that the lower court had referred to it as a bank, but said that notwithstanding that it wasn't a bank, it was a financial advisor, we still agree with the lower court, and that doesn't really affect the analysis because at the end of the day, there is a duty of confidentiality. And this spouse was not a joint owner on these accounts. It was the husband's own account. He was the only registered owner, and he was entitled to confidentiality as to the manner in which he held his accounts. If he wanted to share it, it was open to him, but there was certainly no obligation, legal obligation, forcible obligation that would give rise to damages if the financial advisor didn't tell the spouse. And, the court also makes comments that, we don't have a common law or statutory obligation to notify third parties about an individual beneficiary's choices.
Right.
So that's the first part of the analysis. And that one I think is new, but I'm not surprised, right? You are owed to do it in confidentiality. And, listen, we have issues when we have joint retainers, as lawyers, but that's a matter of contract, right? When we enter into a joint retainer agreement, we say that there are no secrets between both clients. The nature of our relationship is that we act for both of you. We back for both of you equally, and there can be no secrets. Clearly, there was no such contract with the financial advisor. Otherwise, there could have been a different outcome.
Right.
So the next part of the analysis deals with the claim against the children, and the claim, and it's a more and sweet argument. There was an unjust enrichment, and the spouse alleged that there was an agreement between the husband and the wife that these accounts would be designated to her. Okay. Now, the court distinguishes heavily this case from more and sweet, right? So number one is the spouse was not paying the premiums, right? In the more and sweet situation, if you recall, they had already divorced, right? So it was the first wife that got this account or was entitled to the proceeds of the insurance policy as part of the separation. And she continued to pay the premiums after the separation. Obviously they were still married in our case. She was not paying the premiums. So it was a different circumstance. The other issue is that when it comes down to it, it's she couldn't prove that a contract existed. Ultimately, if you look at what the court is saying, there didn't seem to be real evidence of a contract. During the course of the proceeding and the examinations, what the terms were kind of changed. There was no evidence as to when this contract arose. And another really, important issue is the fact that the plaintiff didn't deal with corroboration. So right. Why don't you tell us a little bit about corroboration?
That's right. So Section 13 of the Evidence Act requires corroboration in these kind of cases. So any action by or against heirs or any estate, any action against the estate, you need more than just your own evidence to obtain a verdict or judgment or any decision in your favor. So unless you have that evidence corroborating your claim, you can't really get that decision. And that's exactly what happened here. The court found that Mrs. Fair didn't have any evidence corroborating her agreement aside from her own testimony, which was also not consistent. So I think that was a key point for why she couldn't even get that decision of at the summary judgment level.
Yeah, listen, I think at the heart, and when you're talking about estate litigation, which is different from any other kind of litigation, you are suing, and the person who you are alleged to have a contract with is dead, right? They are not here to say, that's not right. There's no chance that I would have agreed to that. It never happened. And so the court, in order to protect this deceased person who is not here to defend themselves, right, it elevates the threshold that you have to overcome in order to get judgment against an estate. There has to be some corroboration. And I know that the spouse tried to argue that the fact that she was formerly the beneficiary and that he was the beneficiary of hers corroborates. But ultimately the court said, you know what? It doesn't really corroborate because you are not the irrevocable beneficiary of this policy, which implies that you could change it at any time.
That's right. And
so, but I think at the end of the day, ultimately, the court was just not convinced that there was an agreement. It was too wishy-washy. There was no corroboration. She didn't suffer any deprivation because she didn't contribute to it. And the court said, we're going to leave it exactly as it is. So I think that concludes our podcast for today. Until next time, we want to thank you for listening. I'm Jonathon Kappy.
And I'm Mohena Singh.
Should you have any questions, please email us at info@hollandhull.com or contact us through the contact pages on the website. Have a great day.
Thanks.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.